I would like now to take you back to 2005, when you were in the Justice Department, and I want to explain to you why I'm going here. This has to do with torture. The Intelligence Committee was informed in 2006, and Attorney General Gonzalez played a role in this, of the nature of the enhanced interrogation techniques, and we were given a very soft view. Senator Rockefeller became chairman of the committee in 2007 and began a study of 3 detainees and the enhanced interrogation techniques. When I became chairman in 2009, I added that, and we took all of the major detainees and looked at them in a 6-year study. The staff spent long hours analyzing every cable, every email, looking at more than 100 interviews, and essentially putting in a 7,000-page report, 32,000 footnotes, documenting where the information, there are no conclusions, they're just facts. That 7,000-page report has remained classified. I have read it. We have put out a 450-page summary, which is public. And in that summary, we indicate that those cases that the administration spelled out where torture produced operable intelligence was simply not so. We elaborate on that in the big report, and my hope is that one day, not too distant, that report will be declassified so the American people can actually see. But I wanted to ask you some questions along these lines. It's my understanding that the set of talking points were prepared for a press conference for the Attorney General on November 22nd, 2005. The talking points ask whether, and I quote, aggressive interrogation techniques employed by the administration yielded any valuable information, end quote. And in the margin next to this question, you handwrote one word, yes. What information did you have that the Bush administration's aggressive interrogation techniques were effective?
Senator, I'd have to see the document. I don't recall.
Except, after you read the documents, just so you know, the conclusion that we come away with is that when the bill on the McCain amendment was about to be voted on, you forwarded press articles explaining what having these 2 provisions together meant. That was the McCain amendment prohibiting torture and confining it to the Army Field Manual.
Yes.
And the Graham amendment, which would bar habeas. In other words, a detainee could not use the habeas corpus right to file in a court of law and challenge their conditions of detention. So that was looked at as offsetting McCain, but basically preventing habeas corpus from being used, and of course it was overturned by the court.
Senator, you're absolutely right that it was eventually litigated, as all these things are. Thank you, Senator.
In D.C. v. Heller, the majority opinion written by Justice Scalia recognized that, and I'm quoting, of course the Second Amendment was not unlimited, end quote. Justice Scalia wrote, for example, laws restricting access to guns by the mentally ill or laws forbidding gun possession in schools were consistent with the limited nature of the Second Amendment. Justice Scalia also wrote that, quote, weapons that are most useful in military service, M16 rifles and the like, may be banned, end quote, without infringing on the Second Amendment. Do you agree with that statement, that under the Second Amendment, weapons that are most useful in military service, M16 rifles and the like, may be banned?
Senator, Heller makes clear the standard that we judges are supposed to apply. The question is whether it's a gun in common use for self-defense, and that may be subject to reasonable regulation. That's the test, as I understand it. There's lots of ongoing litigation about which weapons qualify under those standards, and I can't prejudge that litigation.
No. As you know, there have been a number of Supreme Court cases where the court has made it harder for workers to hold their employers accountable when they have experienced discrimination or be injured on the job. And we've discussed that one case, Trans Am, I think 3 or 4 of us. Let me give you a short list. Ledbetter versus Goodyear Tire, which limited the ability of women to seek equal pay. Gross v. FBL Financial Services, 2009, which made it more difficult to prove age discrimination. And the University of Southwest Texas Medical Center v. Nassar in 2013, which made it more difficult for employees to prove they've been retaliated against for reporting discrimination, including based on race, gender, national origin, religion, and other factors. Vance v. Ball, which made it more difficult for workers to prove just plain discrimination claims. As Senator Whitehouse pointed out, each of these cases was 5-4, and Justice Scalia voted with the majority against the employee in every case. President Trump and others have said, you are the next Scalia. So I think it's only fair to ask you, do you disagree with any of the majority opinions that Judge Scalia joined in these cases? If so, which ones do you especially disagree with, and why? These have already been decided.
I understand, Senator. But again, if I indicate my agreement or disagreement with a past precedent of the United States Supreme Court, I'm doing 2 things that worry me sitting here.